Hi, I'm Sarah Smith. I am with the Center for Computer Assisted Legal Instruction, otherwise known as CALI, and I am excited to be joined today by Professor Jud Campbell, who is the author of CALI eLangdell Press's latest casebook, Constitutional Rights. I
Great.
will begin with a very brief introduction to CALI. I will then very quickly discuss the eLangdell Press model and its advantages for both students and faculty. And then we'll turn to the main event, which is a conversation with Professor Campbell about his new casebook, Constitutional Rights. So real quick, who is CALI? We are a 501c3 nonprofit consortium of law schools, law libraries, and related organizations. Almost every law school in the United States is already a member of CALI. What do we do? In short, we host and facilitate the creation of online interactive legal tutorials for law students. Those are our CALI lessons. And we create open and free casebooks, which is eLangdell Press, which is the subject of the conversation today. We also offer tools and services to law faculty, such as those that help the faculty get the student grades and analytics for our CALI lessons, as well as a tool that allows faculty to both edit and author their own CALI lessons. And then finally, we created and we host a tool called A to J Author, which is a tool designed to create guided interviews that help self-represented litigants navigate the legal landscape. A bit about our CALI eLangdell Press model. Our casebooks are written by law professors and peer-reviewed by substantive experts in the field. We pay authors and reviewers for the materials, and then we give the book away for free. The books are released with a Creative Commons license, which means they are free to adopt and free to modify without permission. We release them in a variety of formats. That includes the Word file, a PDF version, and then two separate ebooks. Again, all of those versions are completely free to anybody who visits our website right now. They aren't just available for CALI member schools. And then we also partner with print-on-demand providers to create print copies at cost. CALI does not see a profit from those print book sales. And then, like any traditional casebook, the casebooks that we provide have notes, cases, questions, and teachers' manuals that are available to faculty only. All right. So considering the CALI eLangdell model, what kind of advantages does that provide? Well, for faculty, they can modify the content freely. They can merge different titles. They can assign parts of the materials. They can add their own content that includes links to media and other sources. It includes images. They can reference class discussion directly within the materials, add hypotheticals, add their own questions, notes, and commentary. They can add their own cases. If there's a new development in the field, they can go ahead and add that to the material because the Word file, again, is available. They can add current events and reflection exercises. For students, the advantages include rearranging, highlighting, formatting, and searching content more easily, again, because the PDF and the Word files are available. They can respond to questions directly within the material. They can add class notes to the material. They can copy material more readily from their outlines, or from the books into their outlines, or they can post material into shared discussion spaces with other students. And then, of course, the materials are more accessible and convenient and lightweight because we do have those ebooks, the Word files, the PDFs, and now our print versions also include loose leaf within a 3-ring binder, so they can just pull out those pieces that they need for that day's class discussion. And none of this even includes the fact that they are free, right? So that's probably the biggest advantage to our students who, when a faculty member assigns one of the CALI eLangdell casebooks. All right, so that's all I have. I now want to jump over to the conversation with Professor Campbell. Professor Campbell is a professor of law and the Helen L. Crocker Faculty Scholar at Standford Law School, where he began teaching in 2023. He previously served as a professor of law at the University of Richmond School of Law and as a visiting professor of law at the University of Chicago Law School and at Harvard Law School. His academic focus is constitutional history and First Amendment law. And his publications include articles in the Stanford Law Review, Yale Law Review, Harvard Law Review, Texas Law Review, Constitutional Commentary, and Law and History Review. All right. That all being said, I will go ahead and stop sharing because you don't need that slide anymore. And my first question for you, Professor Campbell, is which types of constitutional law courses is your casebook designed for? Or in other words, where does it fit into the broader law school curriculum?
Well, great. Thanks so much, Sarah. Thanks for your work on the book and thanks for hosting this conversation.
Thank you for being here today.
Yeah, absolutely. And I appreciate people's interest in the casebook. The casebook was one that I designed for an upper level rights course that I taught at University of Richmond about 10 times actually when I was there. It's a casebook that would be best taught in a class that covers 14th Amendment and First Amendment rights as a kind of basic foundation for the class. The class that I taught included equal protection rights, substantive due process rights, First Amendment speech and religion. And then also, I ended the class with a unit on guns and a unit on takings. But as you mentioned, the beauty of these Cali books is that professors can mix and match, can include some supplemental assignments. And in the teacher's manual, I will mention some supplemental assignments that I've already created for separate courses on the First Amendment that I taught at Chicago and Harvard. So if professors would like to use these materials just for a standalone First Amendment class, that's possible, especially with the supplements that I'd be happy to offer. But the class is really designed for a comprehensive rights survey course. It certainly would be better suited for an upper level course than for a basic constitutional law course. I'm not really focusing in these materials on questions relating to basic methods of interpretation, the sort of modalities of constitutional interpretation, text, history, structure, and so on that you would do in a basic constitutional law course. Sort of assume that students have some familiarity with that. So these are really oriented towards an upper level rights class.
Great, thank you. All right, so now that we know where the book is situated in the law school curriculum, can we talk a little bit about the teaching strategies that you employ in your casebook? So can you highlight some of those strategies that you use and how do they align with current trends in teaching constitutional law?
Sure. So I do orient the materials mostly towards case law, which of course makes sense given that it's a constitutional law casebook and so much of the material is focused on Supreme Court case law. The cases tend to be lengthier excerpts as opposed to having a lot of short paragraph or several paragraph length excerpts of bunches of cases. I tend to focus on just having a couple key cases, and I've tried to select cases that raise the big foundational questions in the area of law rather than cases that are sort of dealing with the minutia around the edges. So when dealing with affirmative action, for instance, I have the Bakke case and the SFFA case rather than covering all of the intervening case law dealing with affirmative action. Same thing with respect to abortion rights, Roe, Casey, and then the recent Dobbs decision, as opposed to trying to navigate my way through a bunch of intervening decisions. Now, in those particular areas of law, it makes sense just to focus on the big picture questions since the major areas of law themselves have been recently upended. But that sort of gives you a reflection of how I have approached other areas as well. Even if they have not recently been upended, it's really a casebook that's heavy on first principles and not as into the kind of doctrinal weeds. And so I think that would make it suitable both as a foundational casebook for somebody who wanted to approach the class in the way that I do, which is to try to give students a big picture of the area of law and its relationship to the sort of themes that cut across the different topics that are covered in the casebook. Or it would be the sort of casebook that provides the backbone, and then professors can fill in the details as they see fit in any particular area. And so that's kind of my general approach. When trying to present the materials as a doctrinal matter, I have tried throughout the casebook to emphasize the ways in which First Amendment rights replicate some of the conceptual problems that students will have encountered in their study of equal protection rights or substantive due process rights. So things like what is it that the tiers of scrutiny system is doing when when the court is using it to try to give meaning to First Amendment rights, and then comparing and contrasting how the court draws on that tiers of scrutiny framework with respect to the First Amendment in comparison to the substantive due process and equal protection rights students have already seen earlier in the course. I spend a lot of time throughout the casebook trying to structure students thinking about rights analysis in terms of scope and strength analysis. So, what is the field in which judges even consider an impingement on the right? That's the scope analysis. And then separately, trying to get students to think about what it is that when we have identified an impingement on a right, what is it then that the right does to limit governmental power? And some rights are absolute, the ex post facto rule, for instance, but most rights that students would encounter in this casebook are actually subject to some limitation when the government has a sufficiently compelling interest. And so that kind of focus of students' analysis on scope and strength is a way of helping to structure their thinking about rights and helping them to outline. So I try to be fairly clear in presenting those doctrinal points, and then try to be pretty light-handed in terms of the way that I think about the answers that one might give to the big questions that the materials present. So try to raise a bunch of enduring questions about the appropriateness of judicial balancing, about the benefits of having more aggressive as opposed to less aggressive judicial intervention in political decision making. Those are questions that come up throughout the casebook, and while I try to be fairly clear about the answers to the doctrinal questions, try to be fairly light-handed in my treatment of the big big picture questions.
Great, thank you. All right, so I'll start with a more general question. And then the second part of this kind of goes back to what you were talking about before about cases being upended, right? And so the first question is, what criteria guided your selection and arrangement of the cases and materials? And with that, how do you ensure that the selection of cases and the materials that you include in the book are relevant to current issues in constitutional law?
Yeah, so the way that I've tried to select cases is in part to find the cases that fit the key themes that I'm trying to emphasize in the case book, and then relatedly to try to find those cases that are cases that students of the area will have learned across any number of classes that they may have taken. So I'm trying to give students this sort of canonical instruction in the field, which requires teaching standard cases, Brown, Loving, etc., while also selecting cases that are raising the foundational questions as opposed to trying to approach the minutia. There are a couple areas where I've selected idiosyncratic cases. In the teaching of the First Amendment, I select a case involving regulation of order shutting down a bookstore for health code violations called Arcara that you're unlikely to see in most other classes because I think it does a really nice job addressing the scope question in First Amendment analysis. When do we ever see, when do we even have an impingement on First Amendment rights in the first place? But for the most part, the case selection is fairly standard. The thing that is emphasized a bit more heavily at the outset of the book than in most courses is the early cases. I spend a lot of time developing at the beginning of the course some of the key themes through an exploration of the foundational decisions in the 19th century and then in the early 20th century. And so the casebook is going to be best suited for those people who are willing to really delve into the history at the outset of the class. Of course, that always generates some inquisitive, puzzling comments by the students about what they're supposed to get out of the beginning unit. What do we take away from this? What do we outline? And the answer there is really that it sets out the key foundational issues that students confront throughout the class and does so in a little bit less stressful environment because there isn't also a doctrinal payoff that students need to be outlining in those materials. And then also the beginning with the historical materials, I think, is especially important today because there are a lot of claims, especially by people who describe themselves as originalists, that rights have a particular form of analysis, that they operate as categorical limits on governmental power, that they're opposed to the idea of being balanced against countervailing interests. And one of the things that the introductory materials, the historical materials in this book are aiming to present is a way of thinking about rights in the late 18th through the early 20th century that to some extent recognized a kind of determinate, legally enforceable, judicially enforceable conception of rights, but also that was paired with an understanding of natural rights that um, allowed the government to regulate rights in promotion of the public good. And the kind of key question in the late 19th century and early 20th centuries was how judges, unelected judges, should think about their role in trying to police the limits of legislative power to regulate rights and promotion of the public good. So it's really that issue that dominated rights jurisprudence up until the New Deal revolution and our thinking about rights. And by focusing at the outset of the class on those cases and those issues, it really presents students a new ability that they wouldn't otherwise have because students won't be familiar with this history, to critique the way that courts think about rights today and to really think for themselves about whether this is a good or a bad way of thinking about rights and to try to denaturalize some of the assumptions that we have about rights. That's the focus. That's the reason why I included so much historical material at the beginning. Hopefully, professors themselves will learn something in the process of teaching these materials. And I think by the end of the class, it's a really rewarding way for students to approach the materials because so much of the doctrine is in flux right now. And so many claims are being made about just the way things are, the way that things have always been, that it is helpful for students themselves to have actually a better understanding of the history, the way that these doctrines developed, than the Supreme Court justices themselves have.
Hey, thank you. And I know you've touched upon this in a few of your responses, but in case there's room to elaborate, how is your casebook different from existing ones in constitutional law? And does it address any gaps or limitations in existing texts that you know of?
Yeah, so I do start with the 14th Amendment materials. Some case books begin with the discussion of the First Amendment and proceed through later amendments. The reason I've organized it by focusing first on equal protection and substantive due process rights and then later on the First Amendment is because, first of all, historically, the development of the doctrine was generally taking place with respect to due process rights and to some extent equal protection rights, mostly rights against states, state governments. That's where the bulk of the case law was, even into the 1930s and 40s. And so, as a kind of logical historical matter, that makes sense to start there. Also, I think that the First Amendment is complicated enough where it's helpful to start with somewhat easier doctrines to understand and work your way through, and then get to the First Amendment. And then by the end of the course, when we do free exercise rights and gun rights, we're in fields where the doctrines are very up in the air, where it isn't clear what's going to happen with respect to the court's treatment of free exercise or what the doctrines are regarding the Establishment Clause. And then gun rights are sort of up in the air as well in the aftermath of the Bruin case and the Rahimi case. Hopefully that organization will work with professors. The beauty of the Cali materials is, of course, they could move things around. There are some textual references in the materials that make reference to earlier materials that have come um, uh, prior in the casebook. And so it would be helpful to keep the kind of basic structure of the class, but certainly would be workable to change things up. In general, the biggest difference between these materials and a standard textbook a casebook that covers rights doctrines is that these materials, both historically and conceptually, begin with a different understanding of rights. So these materials do not assume a modern conception of rights. Rights come from the Constitution. Rights are determinate limits on governmental power. Rights are judicially enforceable. These materials don't make that assumption. Instead, they try to chart how it is that we came to slowly embrace that way of thinking about rights. And then in the process of doing so, to kind of critique that, to think about what is good and bad about having a conception of rights that imposes more determinate legal limits on governmental power. And so that's a major theme of the casebook. The other thing that is not unique to my casebook, but that's worth emphasizing, is that I spend a lot of time in the casebook trying to encourage students to think about the extent to which constitutional law is an interpretation of the Constitution itself, or is instead a set of implementation rules that judges create in order to give practical meaning to underdeterminate constitutional commands. So my way of thinking about this is heavily influenced by Dick Fallon's work on implementation rules. And an example here is the tiers of scrutiny. We may have a notion that there are certain interests that the government is enabled to pursue, that the government's effort to try to entrench racial supremacy, for instance, for particular racial groups is an impermissible interest. And what we need then are doctrines to help tease out when it is that the government has pursued those illegitimate interests and when it is that the government has pursued legitimate interests, because of course the legislation doesn't come with a sticker that tells you exactly what the real motives are behind the legislation. And so we come up with the tiers of scrutiny system, not because the tiers of scrutiny system itself is built into the Constitution. Nobody thinks that. But instead, because the tiers of scrutiny system gives us a more structured, perhaps more predictable and disciplined way of evaluating cases consistently across time and across judges. And so it's an implementation rule. It's a way of giving practical effect to a rule that itself would be difficult to directly enforce. And there are just countless numbers of examples of that throughout the casebook. So that's something that I try to tee up as well.
Great, thanks. And I have one final question for you, and that has to do with the open access nature of the casebook. How do you hope the Creative Commons license will influence the way faculty and students engage with your casebook? What do you hope will be the impact that it has on the usage?
Yeah, well, I think each class needs to be geared towards the professor's strengths. That's certainly one of the reasons I began to prepare these materials, was to try to give my students the ability to engage in the ways of thinking about rights that got me energized, that I knew the most about. And I found that the existing casebooks were inadequate in terms of emphasizing the themes that I wanted to emphasize, and particularly in drawing out the historical progression of our thinking about rights. And so one of the benefits of the Cali casebook is that you could do the same sort of thing with my materials, modifying them in certain ways, and drawing out the themes that you want to draw out without having to start from scratch on a casebook, which it turns out in retrospect is a lot of work. And I had gotten to the point with my materials where I was assigning about half supplemental materials in addition to requiring students to buy a $200+ casebook. And there was a point at which I just thought that was an unethical thing to do. And so I felt like it was appropriate for me as the instructor to provide students with a set of materials that we could use as the foundation for a rights class that didn't cost them an exorbitant amount of money, and where they weren't using that set of materials for half the class. Had I had the benefit of a casebook that was free, I could have combined my supplemental materials with the free materials and saved myself a whole lot of work, and really benefited also from what I did benefit from, which was the added expertise that I got out of teaching from another person's casebook, as opposed to starting from scratch on my own, which would have been not a viable thing to do as a first year professor. And so I hope that these materials can be used in the same way. And I know that a couple of people who've already used the draft materials have approached their classes much in the same way, using my materials as a kind of backbone, so to speak, for a class, but also supplementing with quite a lot of materials on their own. And some of those classes have included rights that are not mentioned in this case, or cases that are not mentioned in this casebook, and then also some of those classes omit some of the topics that are covered in this casebook. And the beauty of having a free casebook is that there should be no associated guilt with doing that, as opposed to requiring students to buy this obscenely expensive and very heavy, backbreaking casebook that covers way more things than the students will encounter and cost them an exorbitant amount of money. And so I hope that this is a further kind of contribution to the field in helping each professor do the sort of thing that I was trying to do in my class.
Thank you. All right. Well, that's all I have. Unless there's anything else you want to add, thank you so much for joining us today and discussing your casebook. It has been an absolute pleasure working with you on this, and Kelly is thrilled to be adding it to its eLangdell library.